Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Dr. Farha and my fellow Master in Islamic Banking and Finance classmates. Today, I would like to present a case study involving Kuwait Finance House versus JRI Resources. This is going to be part of our assignments on this case studies. Okay. Basically, I just would like to enlighten everybody. This is actually a case happening in basically a few hierarchy of the courts, and frankly speaking, it's a quite tough assignments that I have to go through in understanding this case. However, I will try my best to present so that you can get all of you can get easier and better understanding on this case. Okay, let's see what is actually happening in the case involving KFH and also JRI resources. This case is actually involve two parties, which is the plaintiff named as Kuwait Finance House and JRI Resources as the defendant, which is the customer. So what actually happening in this case is actually a default of various Islamic credit facilities granted by the bank, which is the Kuwait Finance House, KFH, to JRI Resources. Let's see on the case background. In year 2008 and 2009, KFH has provided various Islamic credit facilities, including 4 ijarah contract, which is ijarah muntahiyah bitamlik facilities to JRI Resources, which involve the list of several vessels. So vessels ni is actually a big large ship lah. And this ijarah financing was actually granted by few other individuals. So what is actually happened? JRI defaulted the payment and failed to make the outstanding payment under this ijarah facility. So KFH, as the financier, actually sued the clients lah. But before we go through further, I just would like to enlighten all of you on what is the court hierarchy in Malaysia. Okay, so the lowest is actually the magistrate court, followed by session court, High Court of Malaya, and also High Court of Sabah and Sarawak as the same rank, and then proceed to Court of Appeal, and the final one is actually the Federal Court. So understanding this hierarchy will help you to understand this case lah, as we are all actually not law students kan. So that's why I think this is very important for you to understand the case flow lah. Okay, let's continue the case background. So what happened actually in September 2013, KFH has filed a civil action against JRI Resources and its guarantor because they want to recover the amounts that due under the facilities in court. So on the 3rd of October 2014, the High Court actually granted a summary judgment in the favor of Kuwait Finance House and asked JRI Resources to pay an outstanding amount of 118,261,126 together with compensation fees. So actually it's involving a large amount of outstanding lah. So what happened? Of course, when the case is in the favor of KFH, JRI is not satisfied. So what they did was actually appealed to the Court of Appeal against the summary judgment, right? And during the hearing in September 2015, JRR argued that the failure of them to derive the income from the charter actually proceed from leasing of the vessel because KFH failed to carry out major maintenance works on the vessels. And they also allege that the carrying out this major maintenance work was the responsibility of the owner of the vessels, which is KFH. So this is basically the argument of JRR. And then of course, when in the Court of Appeal, the JRI resources claim that High Court actually did not follow the Sharia Advisory Council in the clause of 2.8 in the Ijarah Agreement according to the Islamic Facilities. And we're going to see what is actually this clause is all about, right? But just to enlighten you that this clause actually states that the maintenance of the vessels and the cost should be monitored and dealt by JRR. And this is parallel to the section 56 and 57 of the Central Bank Act of Malaysia in 2009. Okay, so that's why this case, when JR submitted this, the Court of Appeal is asking the High Court to allow the appeal and refer back to basically the SSC. So let's look at the clause 2.8. In the clause 2.8 of the Ijarah Agreement stated that the parties hereby agree that the customer shall undertake all of the major maintenance as mentioned herein, and the customer, which is the JRI lah, will bear all the costs, charges and expenses in carrying out the same. So what are the Sharia issue raised here is whether this clause 2.8 of the Ijarah Agreement is actually Sharia compliant. So that is basically the issues. And because of this, in June 2016, when the case is referred back to the SSC said that the clause was actually Sharia compliant. Okay, again, JRR tak puas hati. So the satisfaction actually raised another issue. But I just would like you all to look at the function of the SSC, because the SSC is being referred in this case. So according to BNM website, in January 2030, actually SSC comprised of 9 members with expertise and experience in Sharia, Islamic economics, law and finance. Okay, and SSC is the highest authority to ascertain Islamic law for the purpose of Islamic financial business in Malaysia. So highest authority lah, and they are the central in promoting a certainty in Sharia and to sustain public confidence in the Islamic finance industry. Besides that, it's also advised the bank on Sharia issue relating to Islamic financial business, either involving the activities or transaction of the bank, meaning the point of reference lah. And the ruling of the SSC serve as a reference for Islamic financial institution in ensuring their business operation comply with Sharia principles. And this ruling of the SSC also may serve as a reference for the court and the arbitrators. So this is basically what is stated by the BNM. Alright, so let's continue looking back at the case. Of course, they are dissatisfied and they continue to apply application to the federal court to determine whether the 56 and 57 section of the Central Bank Act did violates the Article 121 of the Federal Constitution. Okay, because just now they said they argue about the Sharia compliance status of the clause 2.8, but because of the case does not favor them, they actually raised another question. So, and then it was held that the decision matters regarding Islamic finance cannot be given based on the SSC. Okay, and the civil court are not able to adjudge on Islamic law matters because it's not their bread and butter. And this matter can be referred to SSC, but the court actually has the authority to apply Islamic law to the case. Okay, this is actually a bit complicated to understand, but if you look at the case, what they are trying to say is that any reference to the Islamic financial matters should be referred to the SSC, right? But I will explain to you further lah. So let's look at what is said in the section 56 of the Central Bank Act 2009. Okay, this section said, where in any proceedings relating to Islamic financial business before any court or arbitrator, any question arises concerning Sharia matter, the court or the arbitrator, as the case may be, shall take into consideration any published ruling by the SAC or refer such question to SAC for its ruling. Okay, so what this rule said is actually this section require the court to take into consideration that any published ruling by SSC or to refer a question on Islamic law to the SSC in any proceedings related to Islamic financial business. Okay, so the next one, which is being argued also by JRI on the constitutionality, the section 57. And what this section say that any ruling made by the SSC pursuant to a reference made under this part shall be binding to the Islamic financial institution under section 55 and the court or arbitrator making a reference under section 56. So section 57 is actually saying that CBA provides that any ruling made by the SSC shall be binding on the Islamic financial institution and also the court. So this actually makes things become clearer. But disagree, there's a lot of arguments relating to this section 56 and 57, because JRI, they were dissatisfied lah with the unfavorable outcome on the reference made kan by the SSC because the clause was actually Sharia compliant. So that's why they make an application which was filed for referral in the federal court under Article 128 of the Federal Constitution, Section 84 of the Code of Judicature Act, and also several questions on Section 56 and 57 of the CBMA. However, actually, the High Court rejected this application, okay? But the Court of Appeal actually allowed the appeal, and the Court of Appeal ordered that the High Court to make a constitutional reference to the Federal Court. So, maksudnya, this High Court was ordered by the Court of Appeal to refer to the Federal Court, right? Although the High Court has rejected the case. So, I hope you understand at this stage. So you can read later on in these slides what is actually stated by Article 128, Section 84, and also Section 56 and 57, because I just want to go through the question. Okay, so the question that raised in the federal court was, is the section of 56 and the 57 of the Central Bank Malaysia Act 2009 consistent with the federal constitution? Okay, and there are another three small sub-question raised, either Article 74 in the ninth schedule of the Federal Constitution, and then Federal Constitution, either the judicial function of the SAC, Article 8 of the Federal Constitution, that actually denying a litigant punya substantive. Banyak sangat kan law punya terms kan, but another question raised is because all of this actually negative. Okay, is the court entitled to accept or consider the expert evidence? So this is basically relating lah to the function and the role of SAC kan. So let's look at again, why is this case matters? Okay, if we look at the history, okay, this is the first ever case in the history of Malaysia court which is presided by panel of 9 judges. So tak pernah lah dalam history ada 9 judges actually involved in a case, okay? But because this case becomes significant because there were 9 judges involved. I will show you who are the judges involved and what will be their position actually. That's why this case was seen significant, and it is necessary also to have this 9 member of judges because of public importance involving the business of Islamic banking and finance as the subject matter. Okay, and the decision of majority of 5 to 4 also carries significant constitutional value. Okay, I will explain this further in the next slides. Okay, but just understand this case matters because it involves 9 judges. Okay, tak pernah ada other case lain that actually involve 9 judges. Okay, who are the panels of judges that actually involved in this case is actually Tan Sri Datuk Seri Panglima Richard Mylan Jim, and the President of the Court of Appeal, Chief Judge of Malaya, Chief Judge of Sabah Sarawak. There were 4 Federal Judges Court and 1 Court of Appeal Judge. So total there are 9 judges lah. And the council representing JRI Resources, Datuk Malik Imtiaz Sarwar and his team. Kuwait Finance House was represented by Miss Yong Sin Min and her team. Okay, but there are few other intervened party from IBIM, which is represented by Dr. Muhammad Johan Lee, and also Datuk Dr. Cyrus Vidas as representing the BNM. So it's not just judges, many judges, but also there were presence of 2 intervened parties from IBIM and also BNM. Okay. Let's look at what are the issues involved. So the issues was actually whether the section of 56 and 57 of the CBMA 2009 are unconstitutional. Okay, why they say unconstitutional for? Because it's removing the discretion of the court as to the need for expert evidence on the subject matter and making the expert opinion of the SSC binding on the court. Okay, I will explain further to make you sure understand on this. So, what are the arguments involved in this case? Miss Yong Sin Min, representing KFH, stating that the function of the SC was merely to ascertain only whether the transaction complied with Islamic law, and actually they did not decide on the commercial dispute. Okay, meaning that the issue was only referred to SSC pertaining to Islamic law, but not to basically decide when it comes to any case, because the power of deciding is actually falls still within the court adjudication. So while Dr. Muhammad Mohan Lee, which is the counsel from IBIM, also state that SSC are only to state the Sharia or Hukum Syarah position on point. Okay, and they actually have no personal interest in any of the case. They just actually become the point of reference, and they are actually the authority who actually have experience in all the matters relating to Islamic finance. And according to Section 56 of the Act, it's also stated or, and this is also signified options to either seek the advice of the SAC on their ruling. Let's look at what actually the decision made by the federal court. Okay, in the section 56 and 57, okay, the decision was these 2 sections are actually constitutional. Okay, and as they do not amount to judicial decision. Section 56 and 57 also require a court to refer question related to Sharia matters arising during legal proceeding related to Islamic financial business to SSC for its ruling. Meaning, the court have to refer to Sharia matters to SLC for its ruling. Okay, and with such ruling being binding the court to make reference, meaning the court is actually bind for the reference made by the FSC lah, as the subject matter expert. Okay, and the federal court also held that the SSC rulings are solely confined to Sharia matters, and this rule do not have the characteristic of the judicial power. Okay, this is actually answering the question from the lead counsel of JRI, which is Datuk Malik Imtiaz Sarwar, saying that Section 56 and 57 provision effectively usurp the judicial and judicial function and also the power. Okay, so what is basically the view on SSC of this federal court? So the function of SC actually only to ascertain Islamic law applicable to Islamic banking matters, and upon such ascertainment, it was for the court to apply the ascertained law to Islamic banking as the fact of the case. Okay, and this SSC ruling also did not constitute an authoritative decision to the rights or liability of the courts of the parties before the court, meaning they actually does not supersede the court power, and SAC also does not exercise judicial power at all. Okay, and their rulings are only confined to Sharia matters. However, SC is a sole authority in ascertaining the principle of Islamic law for the purpose of Islamic financial business. Okay, so what are the Sharia issues involved in this case? So let's look at the Islamic contract involved. There were 4 ijarah muntahiyah bitamlik, which is the ijarah facilities, and also financing facilities involved, which is murabahah, tawarruk. Okay, you can read the definition of ijarah bitamhiyah bitamlik later on, as this is actually presented by Ustaz Hazim and Hafizul in other presentation. Okay, but I just put it here so that you can at least understand further on the definition of this ijarah contract. But I just would like to further on what's the issue raised during this case pertaining to Syariah matters. So let's look at what happened in the hearing during September 2015. Okay, JRI actually argued that its failure to derive income from the charter is actually proceed from the leasing of the vessel because of KFH failure to carry out major maintenance on the vessels as the owner of the vessels. Okay, this is the argument of JRI. And JRI also submitted that High Court actually erred in not seeking a ruling on Sharia issue relating to the Sharia compliance of Clause 2.8 in the Facility Agreement that states the customer, which is JRI, shall undertake all of the major maintenance and bear all the costs, charges and expenses. So they were actually arguing whether this clause 2.8 was Sharia compliant. So this is basically the main issues involved. Okay, besides the court has erred in not seeking ruling on Sharia matters to SCE. Okay, let's see why this matter go on appeal. Okay, this main reason, it's obviously because of the High Court granted summary judgment in the favor of KFH, right? Which is instructed JRI Resources and its guarantors to pay the outstanding amount to KFH. And the second main reason was because of the SC ruling did not favor JRI Resources, because the clause 2.8 were actually Sharia compliant. Okay, because of these reasons, JRI Resources then decided to challenge the constitutionality of the role of SAC in its appeal case to the federal court. Okay, so in the court of appeal, this was basically the previous lah, and when the SSC come back during the 2016 to saying that the contract was Sharia compliance, of course their resources actually is dissatisfied. Okay, and then because of this also, then only decided to challenge the constitutionality of the section 56 and 56(7) of the CBMA lah. Okay, so when all of this basically happened, okay, the question of the federal court in questioning of the federal, either the section 56 and 57 unconstitutional for removing discretion of the court as student for expert evidence on the subject matter and making the expert opinion of the SSC binding on the court. Okay, so these are the two main questions of JRI federal court. So they argued, and the section actually asked to make reference to Sharia Advisory Council for ruling for the court arbitrator, and the effect of these two ruling actually requiring the court not to only duty bound to refer Sharia matters to SAC, but also to legally obliged to adopt the SSC rulings. So arguments by all the parties regarding these questions, from the IBIM, from the BNM, from KFH, and also counsel from JRI Resources. They were saying the few arguments is actually SSC is actually recognized as a statutory expert body, and they provide impartial expert opinion, and the SSC also cannot be hired by any of the litigants. Therefore, they have no personal interest because they cannot be hired, right? And they only stating the position of the hukum syara on point. So other arguments as well, they stated that the parties involved are actually allowed to provide their own Sharia expert view on the Sharia question, which is actually referred back to the SAC before they make any rulings, okay? Because the chance were given to JRI and also KFH to provide the expert opinion to the SAC before SAC came out with their own finalized ruling on the clause 2.8 of the Sharia compliance status. So what are the things that we actually observe? That the section 56 and 57 also do not deprive a litigant's due process. So the question on the second question was seen affirmative, okay, because the SSC may take into consideration the expert opinion before issuing a ruling, meaning they don't only do their own ruling, but they also take into consideration the expert opinion, okay, before they finalize any rulings. And the parties can always submit their expert opinion in writing to the SSC. So therefore, there is no obstacle to bring their individual expert witness for the case. So this issue is actually solved, okay, and we see that the question 2A is answered affirmative. So if you are the judge presiding over the case, what will be your decision on the case? Okay, let's see what is the power of the civil court judges. As the civil court judges are not trained and they are not familiar with the Islamic law, the civil judges also are not competent to ascertain on the position of Islamic law on financial matters, as this is not their bread and butter. Okay, so meaning that the judges of the civil court are not the subject matter expert. So if they are not the subject matter expert, how are they going to make decision based on something which is they are not trained and familiar with? Okay, so that's why the role and function of the SAC is important, as SAC is seen as the authoritative body that review when it comes to Sharia matters in Islamic finance. Okay, and the definition of SAC is actually expert body where they provide expert opinion. Okay, if you want expert opinion, so the SAC will provide this expert opinion, but in related to Islamic financial matters. And the members of the SSC, which is the Sharia scholars, also specialize in Islamic finance, and they are also industry practitioners and legal practitioners themselves, besides presence of academicians in related fields. So you can see at this stage that SSC are comprised of the experts in their field. Okay, when this case actually happened, so what can we do to avoid the similar kind of transactions to be structured, okay, and avoid the same kind of problem faced in this case? So I would suggest that the customer should understand the contract fully before entering into the agreement, and the financier, which is the bank, should make all the clause and terms clear to the customer by being transparent and fully disclose all terms and conditions, besides making sure that the customer fully understand the contract to avoid future dispute. Okay, this is one of the solution. Thus, both parties, which is the banks and also the customers, may want to agree upfront, okay, before they enter into any financial agreement for all SAC rulings to be binding over them. Okay, then the other point is there should be also a detailed agreement on liability limits and its boundaries drafted out in the agreement before both parties agreed to enter into the financing agreement. So both parties kena understand lah on the limits and liability. Although like what happened in this case kan, I think that the owner, which is the KFH, should be responsible, which is following the contract. However, but because of this matter can be negotiated, that's why it is agreed lah in the agreement stating that the customer should bear all the costs and expenses in maintaining the vessels kan. And then what we can do also, the customer should be made accessible to refer of any Sharia issue to the Sharia panels and agreeing to the same with the financier before signing the agreement, right? Instead of raising it only when they have defaulted on payment. Because if you see, most of the cases happen before this. The Sharia issue is only raised after they have defaulted the agreement. So why they don't raise this issue before they enter the agreement? Why only raise it only after they default on the payment, right? So this is another point to basically to ponder lah. So just to summarize that Sharia Advisory Council, which is appointed by YDPA to represent under Bank Negara Malaysia, is actually the authority and the reference point to ascertainment of Islamic law for the purpose of Islamic banking and financial business. So this is the highest authority lah, right? So the points to ponder, like I said just now, was actually why Sharia challenge only arise in the course of defense brought up by delinquent customers. Okay, is it to avoid liability to pay back the facilities really enjoyed by them, as in this case? Why they don't raise it in the first place before entering into agreement? Okay, isn't that should be much better rather than only raising it when there's a problem arise? So even though the majority of the court are the things that we should see in this case, okay, another take back point, take home point, the majority of the court, which is the 5 judges, I would say that this is a simple majority. Although they upheld the validity of the section 56 and 57 of the CBA, from point and view of the other minority judges, okay, the 4 judges, this will fill many questions on this issue in the future. So there are another points to be argued lah. So we have to relook back into this case. Okay. With that, I end my presentation. If you do have any question or you do not understand the case flow, feel free to refer to me. We're very happy to enlighten you the argument of the case and the significance of the case in our studies, right? Thank you all. Thank you, Dr. Farah. Thank you all my classmates. Hope this presentation benefits all of you. Assalamualaikum warahmatullahi wabarakatuh.